Thursday I mentioned it to make it list for withdrawal, my lord, today, but that was not listed. Tomorrow, sir, tomorrow, my lord.
My lord, this matter may be listed for motion on Wednesday. This is regarding recruitment for the post of constable in CRPC, my lord.
Regarding
Recruitment of CRPC, my lord. My lord, constable.
recruitment.
CRPF.
What is
I'm sorry,
recruitment?
my lord. CRPF, my constable, my lord.
No, what is recruitment?
Recruitment.
Recruitment.
Appointment.
Friday.
Yes.
May I
My lord,
please-
another matter, my lord, item number 23, my lord. In this case, my lord, the respondents have filed affidavit in opposition, my lord. I may be allowed 2 weeks' time to file reply. my
Ms.
lord.
S.B. Chaudhary, learned counsel for the petitioner, prays for and is granted 2 weeks time to obtain instruction and file rejoinder affidavit in response to the counter affidavit filed by the respondents. Let the matter be listed accordingly.
May I please, Lordship, my lord, I am praying for listing, my lord, one matter, my lord.
Yes,
Yes, my lord, in item supply 40, I have filed an additional affidavit. I may be allowed to bring that on record.
yes.
My lord, I am praying for listing, my lord, one matter. For admission, my lord, selection and appointment of grade 4 post, my lord.
Next week.
May I please, Lords, I am praying for listing of a matter for motion on Wednesday, my lord. Some emergency is there regarding appointment of CTPO, my lord. This matter was last issued on Friday. However, it was withdrawn because respondents were not made a party. We have again filed it today, my lord. Lordship, I am praying for Wednesday. Oblige, Lordship.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item 31 to 34, lordship. Lordship, we are awaiting the updated instructions in these matters, lordship.
31 to?
34.
Yes, you have informed the other side?
Lordship, I have
I'm
informed.
praying for the petitioner applicant, my lord. I'm praying for a fixed date, my lord. I have some urgency, my lord.
Now, what are these IAs for?
I ask for keeping some post vacant, my lord.
All right. Miss S. Barua.
Lordship, P. Barua.
P. Barua, learned counsel appearing for the respondents in this batch of petitions have sought adjournment with a request to post the matter again after 2 weeks so as to enable her to obtain updated instruction. Since the prayer is made with the consent of Mr. N.J. Khatonia, learned counsel for the applicant petitioner, the same stands allowed. List these cases again on the request of Mr. Khatonia. Let this matter be listed again on 11th of December 2024 as fixed items.
My lord, may I pray out on 13th, my lord.
All right,
On 13th.
13th of December.
Deeply obliged.
Oblige, lord.
May I please, your lordship? Lordship,
Yes.
I beg to mention for listing of a one matter for admission, lordship, matters pertaining to non-payment of retirement benefit, lordship, on next week, lordship.
Second week of December. Second week of December.
May I present, Lordship? Lordship, I beg to mention item number 28. Lordship, Mr. A. Boro is conducting the matter. His father passed away last week. So he has gone back to his native place.
Item number 28.
28, Lordship. Lordship, can it be
The
taken up?
prayer of learned counsel for the petitioner. This matter stands passed over for the day.
May I please, your Lordship? Your Lordship, in respect to item number 21, I am praying for an adjournment, Lordship. I have obtained the consent from the other side, Lordship. Mr. V. Pathak has some personal difficulty, Lordship, today.
With the consent of learned counsel for the respondents, a prayer for adjournment has been made in this case on the ground that the learned arguing counsel, Mr. B. Pathak, is facing some personal difficulty today. Since the prayer is made with the consent of the other side, same stands allowed. List the matter again after 2 weeks.
Oblige, Lordship.
May it be, Lordship. No, I want to do a matter, my lord, tomorrow. Let it come down.
May I please, your lordship? Lordship, prayer for listing of a WPC. It was last listed on 31/5.
Second week of December. Second week of December.
Item number 6, as my senior is out of station, adjournment for the day.
As paid for by petitioner's counsel, this matter stands passed over for the day. 6.
Lordship, I pay admission matter for listing, Lordship.
Second week of December.
May I please, your Lordship? Your Lordship, in this matter, as per order dated 31/8/2024, your Lordship.
Lordship, this matter will be passed over for time being, your Lordship. My senior is coming, Lordship. He will apprise your Lordship.
Wait.
Instruction was called for from HG, your
Lordship.
Lordship.
Yes, what do you want?
Lordship, time being, your lordship, I pray for
Why?
time. My senior will appraise your lordship. He's
No.
coming, your lordship.
Yes, Mr. Bora.
I have taken.
You want some water?
No, I don't want water.
Hmm.
Here I have taken verbal instruction because I was out of station, I could not get it. But particularly area payment for junior engineers, it is 11 to 14. He took voluntary retirement in 2018. That regarding junior engineer, we do not pay. AG is to maintain only record, it is sent for, it is the concerned department is to pay. That is clear instruction and I'm submitting at bar. If it is required, I place an written instruction on Wednesday.
Then you produce the written instruction. We'll
Yes.
fix it. Not Wednesday, next Monday.
No, Monday I'll be not available. If not next year, then another next to next year, it is 5th or 6th, I think.
So then we'll fix it on Friday.
Friday also I'll be not available because I'm having some domestic arrangement in my residence. On Friday you can I put it. Oh, Wednesday I can put it, Melody, if you want.
All right, heard Mr. So-and-so, Learned Majumdar, Learned Counsel for the petitioner. Also heard Mr. C. Borua, Learned Counsel appearing for the AG, bracket A&E, bracket close, comma, Assam, who submits that although he has received some verbal instruction, yet a request is made to post this matter again on Wednesday, that is give the date, so as to enable him to produce written instruction from his client to the effect that the office of the AG A&E has no role to play in matters of release of arrears salary of officers in the rank of junior engineer.
It is a concerned department.
Of the junior engineer, and it is for the concerned department to process the matter. In view of the above, register to list this case for motion again on Wednesday. Miss so-and-so, Miss J. Bora, Learned Counsel is present for response numbers 1, 2, 3, 6, 6. You also obtain instruction on this.
Obliging.
In this case, my lord, I am appearing on Accountant General. Though your instruction or order was given for supplying extra copies, so far it has been not been supplied to
It's
us.
not given extra.
No,
copies.
not
Will
been given. That's why we will not take instruction.
Mr. Your name, please?
Why would we, my lord? Why would we?
Mr. So-and-so, Learned Counsel is present for the petitioner. Mr. C. Borua, Learned Standing
I'm
Counsel
for it, 8, my lord.
for the AG A&E submits that due to non-furnishing of extra copies, he could not, extra copies of the writ petition, he could not obtain the necessary instruction as per the order dated 6/11/2024. Miss M. Bhattacharjee, Learned Additional Senior Government Advocate Assam, is present on behalf of the state of Assam. Be that as it may, 2 extra copies of the writ petition be furnished to Mr. Borua. Let this matter be listed again after a week so as to enable.
After 10 days. Obliged.
May I please, Your Lordship. Earlier order, Your Lordship, kindly see, instruction was sought for my lord.
Who is appearing in this case? Ms. Bhattacharjee, are you appearing in this case?
Lordship, I am appearing, but it seems that I think extra copy not served. That's why the letters are lying here, Lordship.
Sir, already served. Already served.
If it is served, then it would be, you just see.
My lord, I will serve, my lord. No problem, my lord. I will serve. I am not denying, my lord.
Heard Mr. A. Manaf, Learned Counsel for the petitioner, Ms. M. Bhattacharjee, Learned Additional Senior Government Advocate Assam, appearing for the state, submits that due to want of extra copies, she could not obtain the necessary instruction. Mr. Manaf undertakes to furnish extra copies of the writ petition to Ms. Bhattacharjee within 2 days from today. In view of the above, let this writ petition be listed for motion again after 10 days, so as to enable the Learned State Council to obtain instruction.
Obliged.
Lordship, here they had challenged a suspension order, but that was renewed. But from 24 September, the petitioner deserted service and he is an absconder now. So that is the
He got
position.
missing, my lord. So we
Sorry?
did not want to pursue this matter.
We don't want to pursue this matter. Okay, so I'll close it,
Yes.
not pressed. Your name, please?
B Das.
Ms. B. Das, learned counsel appearing for the writ petitioner. Are you, are you in this writ petition?
Yes, writ petition.
Your name is not shown. Have you signed the wakalatnama?
No, my
Then I'll record your senior's name,
T. Shom.
T. Shom.
Yes.
She is also not there. Is there anyone who is in this case whose name you can give? This is item number 4, is it not?
Four.
Miss S. Sharma Hazarika, learned counsel appearing for the writ petitioner submits
P.
that.
Telly.
Huh?
P. Telly.
P. Telly, learned, Mr. P. Telly, learned counsel for the petitioner submits that he has instructions from his client not to press this writ petition. Miss B. Sharma, learned CGC is present on behalf of the respondent. On the request of the petitioner's counsel, this writ petition stands disposed of as not pressed.
Item 5.
Lordship, they have challenged a memorandum, Lordship, and also a memorandum dated 12/7/23. Although it's a file long back, Lordship, but notice not yet issued.
Notice not yet issued.
Not yet issued. So memorandum, they have challenged that it is not in accordance with standing order.
Yes, what is your case? Please argue. On the request of petitioner's counsel, this matter stands passed over for a week. Ms. B. Sharma, learned CGC is present on behalf of the respondents. List accordingly.
Item 7.
Yeah, please, Your Lordship. Your Lordship, this is a matter relating to family pension. What has happened here is my instruction from the Assam regiment is, Lordship, this pension papers are processed through the Jilla Sainik office, Lordship. There are some discrepancies which have been noticed, and it has also been informed to the Jilla Sainik office and to the petitioner. But those corrections have not yet been submitted to the Assam regiment, Lordship. Therefore,
But tell us, is she entitled to pension?
Yes, yes.
Then where will she go? This lady is
No, no.
widow.
The discrepancies have to be removed in the forms, no? That has to be submitted.
No, but who will do that?
The lady herself, Lordship, the petitioner, through the Zilla Signing Board, it will come to us. But we are open, like if she also submits to us, we'll process it.
All right, heard Mr. S. Hawk, learned counsel for the petitioner also. Peruse the amendments made in the writ petition. The petitioner, who is the widow of a sepoy serving under the Assam Regiment of Indian Army, has approached this court by filing this writ petition contending that despite her entitlement under the rules, family pension has not been paid to the petitioner. Although her husband had died on 24/2021, full stop. On instructions, Mr. R.K.D. Chaudhary, learned DSGI, appearing for the Union of India, DSGY, appearing for the Union of India. Acha, DSGI, appearing for the Union of India, submits that the petitioner would be entitled to receive family pensions, full stop, pension, full stop. However, due to some discrepancy in the form presented by her, routed to the
Jilla Sainik Welfare Office.
Jilla Sainik Welfare Office,
Borpeta.
The family pension could not be released, full stop. Mr. R.K.D. Chaudhary has submitted in his usual fairness that if the petitioner so chooses, she can submit the rectified form directly to the office of the
Well, it could be go through the Jilla Porishad, Jilla Shoni board. It will be better, man.
That office usually routes it. So far as military personnel are concerned, the Jilla Sainik Welfare Office.
Usual fairness is alage. Mr. R.K.D. Chaudhary therefore submits that as soon as the rectified form is presented before the Jilla Sainik board, necessary steps for release of the pension amount, family pension amount will be initiated. Having heard the submission of learned counsel for the, no, either right, Mr. Hawk submits that his client will do the needful for presenting a rectified form before the Zilla Sainik Board. Full stop. Be that as it may, considering the nature of grievance expressed in this writ petition, the matter would call for further monitoring. As such, issue notice returnable in 4 weeks. Since Mr. RKD Chaudhary, learned DSDI, has accepted notice for respond numbers 1, 2, 3.
3 and 4 also, Lordship, but here, Lordship, respondent number 2 has got nothing to do in the matter, and 4, it should be Lordship Borpeta. They have made Kamrup a party.
Okay.
Right. These are cosmetic 1 to 4.
1 to 4.
You are appearing?
5, my lord.
And Mr. BK Sen, learned counsel for respond number 5. You are standing counsel.
My lord, impaneled, not standing, my lord. Impaneled of Central Bank of India.
No, but then we don't know. Then you have to file a wakalatnama. I 1 to 4 service of notice is deemed to be complete
On the next.
on the said respondents. Mr. BK Sen, learned counsel, promised that being the impaneled counsel, he is authorized to represent the respondent number 5. Service of respondent number 5 would therefore also be treated as complete, subject to a duly executed wakalatnama by the respondent number 5 being placed on record within 2 weeks from today. Full stop. Extra copies of the writ petition be furnished to the learned counsel for the respondents. The petitioner is granted liberty to submit a modified stroke rectified form before the respondent number 4, which would be the Zilla Sainik Welfare Office at Borpeta, comma, so as to enable the respondents to process our claims. Liberty is also granted to the petitioner to file additional affidavit, bringing those facts on record if so advised. This is the matter for admission after 4 weeks. At all, I know pendency of this writ petition shall not be a bar for the respondents to process the application of the petitioner. This is the matter again for admission after 4 weeks.
I'm obliged.
Item number 8, my lord, your lordship is directed to take the instruction. They have served a copy to me, man.
That's actually not instruction that first day when it is come.
Yes, ma'am.
Before that, I took instruction from this pediatric training. On the basis of my instruction already, they have assured that it will be done. Accordingly, it was according to us, it is been assessed and it is been returned to Treasury officer. Treasury officer. Just now, my learned, I have sent by WhatsApp message this one to him also copy service. My learned friend, according to him, is not satisfied by this.
Because reason behind it, my lord.
No.
Just for
Nothing.
me. Just for me.
Sorry.
And if he's not satisfied, my lord.
Just a minute, just a minute.
He's 52.
So, Mr. Chaudhary, you have to now also challenge this if you're not satisfied.
My point is something different, my lord. Lordship, what happened in the instant order that has been passed, my lord? They have stated that my basic salary has, as per I was died on the, my lord, attack of extremists, my lord, in 1997, my lord. Thereafter 2006, they have given some increment. 1985 notification has categorically stated that the salary along with increment, my lord. If you lordship go through my note, my lord, everything has
So
been.
you are entitled to a bigger amount.
Yes, my lord.
Exactly, that's what I'm saying.
Yes,
Why
ma'am.
don't you say so in an affidavit?
Then I shall, they can file the affidavit, my lord, I shall reply, my lord.
No, they already sanctioned what they think is right.
Yes, ma'am.
If you are not happy with it, you may have a case.
Yes, my lord.
But then you have to bring it on record, no?
Yes, my lord.
So what do you want to do? Should we close this with liberty to assail this or what? You decide.
My lord,
Whatever is
by-
convenient for you,
By
because
way of, my lord, 65, by way of additional affidavit, I can file, my lord.
yes, but then you will be taking a risk. Somebody
My
will-
lord, liberty may be granted to file my. Yes, sir, please, necessary.
You
Because,
decide.
my lord, it is a pension case, my lord. I can show your lordship, my lord. They have fixed 12,000, my lord. The salary of the ranger at that time was 12,000, my lord. Subsequently, now
Acha, he has a prayer of refixing also. Then why should we not give him additional?
that is the prayer.
All right.
Done
I heard Mr. NNB Chaudhary and counsel appearing for the writ petitioner. The petitioner herein is the widow of a forest range officer who has approached this court inter alia seeking special family pension. Forest range officer who was killed in extremist violence and has approached this court by filing this writ petition inter alia, praying for an order for grant of special family pension. Full stop. Today, when the matter is called up, Mr. C. Borua, learned standing counsel for the office of AG A&E Assam, has produced a copy of the communication dated 11/11/2024 to submit that instructions have already been issued to the Treasury officer to release the amount of family pension, a special family pension, as indicated in the said order. First up, Mr. NNB Chaudhary, learned counsel for the petitioner, however, submit that his client is not happy with the quantum of special family pension.
That is not as per law, my lord.
The same is not in accordance with the rules. Having regard to the submissions made at the bar, this court is of the opinion that the issues raised in the writ petition would call for further examination, since there is a specific prayer in the writ petition for issuance of a direction for refixation of the special family pension. First up, in view of the above, issue notice returnable in 4 weeks. Since Mr. Who is appearing for whom?
I'm paying for
Let's go one by one. Who is for respondent number 1? Since Mr. C.S. Hazarika, learned government advocate Assam, has accepted notice for respondent number 1.
4 and
Mr.
7.
Huh?
1, 4 and 7.
1, 4 and 7. Mr. I. Bothaku, learned standing counsel, Forest Department Assam, for respondent numbers
2 and 5.
2 and 5. And Mr. Who is for finance? Mr. B. Gogoi, learned standing counsel, Finance Department Assam, for respondent numbers 3 and respondent number 3. And Mr. C. Borua, learned standing counsel, AG A&E Assam, for respondent number 6. Service of notice is deemed to be complete in this case. Extra copy of the writ petition be furnished to the learned department counsel so as to enable them to obtain instruction. The petitioner is granted liberty to file additional affidavit assailing the letter dated 11/11/2024 if so advised. However, such a recourse would not prevent the petitioner from accepting the sanctioned special family pension without prejudice to her rights and interest in the writ petition. Let the writ petition be listed accordingly.
Extra copy be wrote, because I took it from the page.
Yes, number.
With results.
Lordship may recollect. This is a case of premature retirement of the petitioner, an associate professor in psychiatry of the LGBRI Mental Health Institute. He is having 10 years more service. At the present time, he's 55. He can continue up to 65. He is likely to be promoted. And he is one of the aspirant for the post of director also. Leaving all aside, he has been sought to be punished by cutting short the whole process of the departmental proceeding, and the director illegally and most arbitrarily and maliciously took resort to 56J of the fundamental rules and retired him. Why I say maliciously first? He made 2-3 attempts to proceed against me departmentally. Every time he got the rebuff from this honorable court. He put me under suspension. That was struck down by this honorable court. Thereafter again, he put me under suspension. That was struck down. Departmental proceedings were initiated on certain grounds, charges, LS charges, which are, one of the example is that certain papers pertaining to my initial appointment, which was forwarded to me, showing the approval of the authorities and all for my appointment, that I submitted along with this petition. That was also one of the charges brought in. That's how bogus charges were brought in, and this honorable court finally stopped both the proceedings. Those are there.
Just a minute. Can you have the conference outside, please? I'm getting disturbed. Yes.
Sorry. And finally, when he could not proceed, he resorted to 56J. 56J apparently is not applicable to me. 56J is apparently not applicable to me. Kindly see. And that initial for the time being, Malad, before going to this, initially that proceeding was initiated by the OSD. OSD issued a notice to my boss, and I was asked to submit the details against me, the documents, everything. I came before this honorable court. This honorable court said, well, you don't take any coercive action. If you have anything with you, you cannot proceed. Don't take any coercive action against me. Finally, in that proceeding, this honorable court has passed an order. Don't take final decision without the leave of this court. You cannot pass. Despite all that, he has issued the final order, and that too, after he was under the order of retirement.
He means the then director.
The then director. He was already to retire. Just before that, or immediately after retirement, after the date of retirement, he was continuing. He says that I am continuing with an order of this honorable court. But this honorable court said only that this interim order will not be applicable so far the post of director is concerned. He may have in some other capacity, but not as the director.
So now he is still holding the office of director.
Now he is not holding. Someone, the officiating director has come, and this honorable court on the last occasion, the second writ petition, that is the first one when I came, challenging that proceeding 56J. That proceeding, this honorable court said that you rather review it. You look into it and review the decision. They have just issued an order, so-called review order, saying no, nothing is there, and that was passed by the officiating director.
Where is this review order is challenging 601?
Yes, now in the second writ petition.
Where is the order? Which page?
Page 82, Lordship may kindly look into. Lordship got it, my lord?
Page 82.
Page 82, Annex 22. It is order dated 5th of November 2024.
Yes.
I'll just place it, my lord. In compliance to the provision of periodic review under FR 56J, order of Honorable Guwahati High Court dated 3/10/2024 in WPC Census, the matter has been reviewed and appropriate authority, appointing authority, that is the appointing authority is of the opinion that it is necessary to retire the government servant in public interest. No, now therefore, in exercise of the power conferred by Clause J of Rule 56 of Fundamental Rules, the competent authority hereby retires Dr. Dhrubajyoti Satia, Associate Professor, Physics Secretary, with effect from the afternoon of 17/9/2024 on completing 55 years of age. Dr. Satia has already been paid a sum equivalent to the amount his pay and allowances for a period of 3 months, calculated at the same rate at which he was supposed to be drawing them immediately before his retirement. This is issued as per direction of the ministry, via communication dated 4/11/2024, that has not been placed. Now, does it say any region? Well, kindly see. A person holding a substantive post and he is having the tenure for another 10 years to go, and that too, he is not an ordinary officer. My lord, he is an asset to the society.
No, I understand. All right. Now, the question now is, what is the order you are seeking today?
I am seeking that this should be put up not immediately.
Cannot be done.
He is in appointment.
I'll tell you why. You may have a very good case on merit.
Yes.
Mr. Mohanto. Let us find a way out where early redressal of grievance is possible. But it has to be a reasonable request.
My lord, I agree with your lordship, no doubt about. But
He was sent out of office on 17/9/2020.
I came before this honorable court immediately thereafter.
Correct. So now there is another order. So this order, 17/9/24 is merged in the order dated 5/11/2000.
Yes.
This order is set aside, he will be reinstated.
Yes.
But he can't be reinstated on an interim order.
My lord, there are things to be looked into from different perspectives with respect to.
I am saying get a
particular
final
fact.
hearing next week. But without a final hearing, there is nothing
Well,
that can be done here.
Yes, lordship.
You want it
proposes
next week, get it next week.
Next week, I have no issue. I want a disposal.
course.
I want, because my concern is lordship.
I agree with you. I agree with you. You are entitled to an answer. But in the facts of the case, it can't be that interim this is state, so he will be continuing in
So
office.
the
That
rules-
can't be. That
Lordship
can't be
will,
the case.
lordship will kindly look into FR 56J for a moment.
You are again arguing on merit. I am saying
Why I am saying, my lord?
final argument today, then argue finally today.
My lord, no, I am ready, my lord, otherwise, but then,
Mr. Chaudhary,
but then,
Well, as far as I am concerned, I am the earlier director, my lord.
what?
All throughout the blame was on the earlier director.
Okay, then,
Now the predecessor successor has also
Acha,
reaffirmed the order.
what about
So
the-
therefore the allegation here goes, my lord.
All right.
I have got the records, my lord. When I did pass the order, that record is there.
But now it is not,
Yes.
you are not in the picture. Now it is for them to.
Yes, virtually it will.
Because,
Even I have been made a party here. That's why I'm before.
It's all right. He is alleging malafide.
Yeah.
But the point is, the dimension of his case in the first round has undergone sea change now.
This
Because
team is
first
out.
round it was,
my lord,
please, Mr. Mohan,
see, change in the
let me,
sense.
I am trying to help both the sides.
Yes.
See, pushing for an order which is not coming is of no use.
No, my lord,
So I do agree that your client is entitled to an early answer.
yes,
But he cannot come back to office on an interim order.
Yes.
If you insist, I'll pass an order, you'll prefer an appeal, it'll take months and months.
my lord.
Or do you want an early hearing? That's what I'm
Yes,
saying.
that's of course,
Yes.
but I just placed one.
It has to
aspect.
be set aside. 5/11/2024 has to be set
Before
aside.
it is set aside, can it
Cannot.
not be put up, not because it
Then
is
you argue
apparently
that-
illegal. That is what I am pointing out.
You argue
And
that.
if your lordship wants that we may accommodate, because I am worried, once it goes for hearing, we never know when it will come. And if your lordship accommodates, then of course.
Certainly, we want to do justice, but we have to do it in accordance with law.
But it, my lord,
His
not only
relation-
justice to me, it has a reflection in the society itself.
His relationship with his employer has snapped
Yes.
on 17/9/2024, which has got an affirmation by the order dated 5/11/2024. To revive and restore it, this order has to be interfered with.
True. And no doubt.
Unless that is done, he cannot be brought back. Every government official, when he comes back to office, there are many other entities.
Yes, this is the procedure this court has been following.
Yes.
We have been doing it.
The order has to be illegal,
My-
otherwise
my-
it's not.
My concern is, anyhow, when the initial order itself is basically ab initio bad, then what is the option remains? What is the option remains? That is what my contention
That-
is. And Lordship says that.
If
it
you
can
are
be taken
convinced,
care
then
of.
you argue on that, on the
Yes.
interim relief, then I will consider it
No.
in accordance with law.
Yes.
You are entitled to argue. I am not stopping you from arguing.
Yes.
But then I will give an answer this way or that way.
Well, definitely.
And then
I
the-
cannot say that this court should pass an order in this way only.
But as I can see, there is always a little anxiety to go fast. So I can see through the process, and I find that
I leave it to your Lordship. Lordship may fix a date because I need, my friend is also there. And Lordship has seen last 2-3 occasions. He is so busy and we had to go back without opening our brief here.
But I do appreciate your anxiety. People want quick answers.
Yes.
Yes, who is appearing for the respondents? And I'm not at all indicating that your client doesn't have a good case. I'm not saying that.
No, Malad, not.
All I'm saying
Only
is what
thing
is the
Lordship
relief?
procedural part.
That's right.
Lordship is on procedural part.
Procedural.
I agree to that, madam. No doubt about that. Normally we have been doing it. Whenever such termination order comes, retirement order comes, court will like to go into the merit and decide.
Insofar as this 5/11/2024 is concerned, Mr. Chaudhary will hardly have anything to say.
Yes.
If you succeed in getting 5/11/2024 set aside, your other writ petition you may not even have to pursue, in which case he may not have anything to say.
Exactly.
So basically it is, who is the employer here? Who is the employer of the petition? You are the employer. You are a CGC. And Acha. Are you both not in the same page?
No.
Why?
Same page. Approval of the ministry order has been passed.
Regarding Lordship, court's part you have to produce.
Have you filed your affidavit?
Our affidavit is not required. It is on the basis of the court's affidavit.
I'm appearing for a council. Ministry is there, and the institute.
So then we'll fix it on an early date, agree on a date. You produce the records and the matter will be taken up for disposal at this. Can you please indicate a convenient date? Be reasonable, Mr. Mohanto. That's all I'm saying. That's all I mean.
Obviously, Lordship will expect that much, that it must be convenient for.
But
and
it has
also
to-
your Lordship. That is why.
No, if the records are there, I can hear it today only, no problem. Do you have the records?
My lord, I have not filed in our affidavit.
No, but you file it by day after tomorrow. Otherwise it will be struck down. You have sent someone home and you are taking time to file affidavit?
What to disable that?
On 5th of November, you have confirmed the order sending him home.
Yes.
He is crying for justice. You have to file it immediately.
But my lord, that departmental proceedings,
Hmm.
and therefore action taken under apartment is not remotely connected.
All right, you justify this order of 5/11/2024. Why have you sent him on retirement 10 years before his date of retirement? What is the reason? You tell us that. Tell us. How much time you need to file an affidavit? 1 week. And then Mr. Mohanto, 1 more week for you to file a rejoinder?
3 days for me.
All right. Then can you all sides agree on a date, non-miscellaneous date?
I'm always there.
Okay. Can it be on the Malad to give her? 10th to give. No? Tuesday. No hearing. No? 10th no. Oh, acha. Yeah. Then 12th, my lord. 10th, my friend has to.
12th of December you want?
Yes.
We'll fix it on 12th of December as fixed items and will be taken up for final disposal. And you file your affidavit by 2nd December. File your affidavit by 2nd December. And rejoinder if any to be filed by 9th December. And matter will be taken up on 12th. Have the departmental records ready. Right.
দশ তারিখে লগ
10 তারিখে ফুকনৰ ছোৱালী বিয়া
মোৰ ঘৰুৱা এখন এৰিয়া
এইটোৱে লেঠা হ'ব দিয়া আহিবা মিলাবা
Lord, could it be on 17 Milord? There's a
You agree any date you agree.
17
Tuesday.
is a Tuesday. 12 Milord, there's some family function.
Any date you agree.
Okay, then 17.
17? All right, you take down. I heard Mr. K.K. Mahanta, Learned Senior Counsel appearing for the rate petitioner in both these rate petitions. Also heard Mr. K. Gogoi, Learned CGC appearing for the respond numbers 1 and 2. And Mr. A.K. Datta, Learned CGC appearing for the respond number 3. Full stop. Mr. K.N. Chaudhary, Learned Senior Counsel, assisted by Ms. R. Kapati, has appeared on behalf of the respond number 4.
Six in the new case, Miller.
Respond number 4 in item 10.
Yes.
And respond number 6 in item 9.
Yes.
So who are 4 and 5 in the you have two private respondents here.
I'm
5 and 6, Mr. Mahanta. There will be difficulty. You have private respondents here. Notice has to go.
Julian Kumar. Julian Kumar to have appeared with say. Hemanta Datta কোন? OSD. Hemanta Datta হয়তো থেকে দত্ত appear কইছে? না।
Can I appear for by name? He impleaded by.
No, you have to produce a wakalat number. Mr. Mahanta, there is problem here. Then it
Now,
cannot-
Mala, the lordship has said that by dusting notice will be served.
Then we can't fix it for admission final hearing.
The next that will be for.
Either you have them deleted or notice has to go to them.
Short date এটা লইল তাৰপিছত ডেটটো ফিক্স
Alog nalage. Okay, Malada, we are deleting. We are deleting 5 and 7.
All right. 5 and 7.
Yes.
What about 6?
6 is appearing, my friend.
6 you are appearing. Acha,
Duty has to be
Mr. K.K. Mahanta, Learned
Oh,
Senior
tell me
Counsel
you.
submits that although respond numbers 5 and 7 were originally implemented in WPC number 6016 of 2024, yet their presence may not be necessary for a just decision on the legal issues raised in the writ petition. As such, Mr. Mahanta has sought deletion of the names of respond numbers 5 and 7 from the area of parties. In view of the above, prayer allowed. The names of respond numbers 5 and 7 be struck off from the area of parties in WPC number 6016 of 2024. In view of the above, both these matters are deemed to be petitioners counsel to file amended cause title in this matter. In view of the above, both the writ petitions are deemed to be ready as regards service. The petitioner has challenged the order dated 17/9/2024, by means of which he was sent on retirement on completing 55 years of age, and the subsequent order dated 5/11/2024, 11/2000, confirming the order dated 17/9/2024, inter alia contending that the impugned orders have been passed, divorce the authority of law, and in a completely arbitrary and illegal manner. Full stop. Since the petitioner is presently out of service, this court appreciates the urgency involved in the matter. Full stop. In view of the above, on the request of Mr. Mahanta, the court is willing to grant an out-of-turn hearing for final disposal of both the writ petitions on an early date. Full stop. Consequently, early date. Mr. Datta submits that a week's time be granted to his clients to file counter affidavit. In view of the above, and on the request of learned counsel for all the sides, these writ petitions are directed to be listed again on 17/12/2024 as fixed items for admission hearing. At the top of the list, the respondents to file their pleadings on or before 2nd December 2024 by serving advance copy upon the petitioner's counsel. The petitioner may file rejoinder within 7 days thereafter, if so advised. The writ petitions will be taken up for disposal at the stage of admission hearing. The respondents to come prepared with the departmental records on the next date fixed.
Apply.
Please file the amended cause title.
Yes.
In the writ petition.
In earlier occasion, this honorable court was pleased to pass an order, my lord.
Yes.
And thereby it was directed to the respondents to pay the minimum pay scale as well as the arrear salary since 2000, my lord. Since April to 99, my lord. And that part has not been complied with. And my lord, since the order was passed in 2021, my lord, lordship kindly have a look at page 35, my lord. And the relevant portion, my lord, para 5, my lord, and lastly 8, my lord.
Acha, you want payment?
No, my lord, minimum pay scale that has to be paid, and arrear salary from 99 April to till date, my lord. That was the court's order, my lord.
Okay, but see, you have not implemented the finance department.
Exactly, your lordship. In fact, this
Petitions are not maintainable without the finance department. Ultimately, without the finance, no payment will come.
No, here in earlier occasion, my lord, that order was there, my lord, it was not made the finance
All right,
department.
so you don't want to implement, then we'll make it clear that it will be subject to issue of maintainability, because Mr. Chetri, you can never get any relief without the finance. Why are you unnecessarily taking a register?
Let I may be
You
allowed
better
to.
withdraw and file with proper pleadings. Because merely adding finance will not be done. You have to plead that the finance has a duty to carry out the court's order, which they have not done. And I'm saying it
That's true.
thinking well about you
Yes,
and your
yes,
client, but if you want notice to be issued, I can. This will further delay the process.
Exactly, my lord.
At the stage of final hearing, this issue will come and
Yes.
again it will go.
That's
You want to
true.
withdraw and file a
Yes,
fresh?
yes.
Mr. B. Chetri, learned counsel for the petitioner submits that due to oversight, the finance department of the state of Assam has not been impleaded as a party in this writ petition, nor is there any pleading in support of the same. As such, he seeks leave of this court to withdraw the writ petition with liberty to file it. Mr. C.S. Hazarikal and G. Assam is present and does not have any objection if the prayer is allowed. In view of the above, this writ petition stands disposed of on withdrawal with liberty to file afresh. You make some pleadings also that how they were bound to comply with the court order, finance department.
Yes.
And how they have failed to do so. Make out a case,
In fact, your lordship, considering the gravity, because earlier court order was also there, I just had a talk with the relevant person here. But they have actually communicated with the finance. I think finance rejected. Of course, my instructions are oral instructions, not very clear, but that's why finance would be
That
required.
is the reason. Everything is about finance. We know what is happening. All department will agree and finance will disagree. And finance is not a party. But why these people are made to suffer so much?
Lordship,
If
true.
they are
That
entitled,
is precisely why, because there is some issue going on here, lordship. If they had finance rejected it, then it went to the department, the parent department here, the social welfare department.
that is the problem. These initial orders are passed without the finance, without hearing them. The court should insist to stand of the finance be brought on record. Deal with it in a judicial order. These are all meaningless exercise going on. 4, 5, 6 years, 10 years going on. The councils don't implement the finance. It appears that people are interested for an early order of disposal only. And look at the poor people running from pillar to post. And when the crunch situation comes, then the court looks into the law. And then it transpires that, oh, this is the law. By then it's too late. This is what is happening. I'm sorry to say. This is what is happening. Today, this court could have issued notice easily. Na? What was the need to go into it? Nobody points out these things. And then after 3 years, 4 years, when the crunch situation comes, contempt comes, then it is discovered that, oh, the whole thing is without any basis. This is a very sad state of affairs, Mr. Chetri. You must also take note of this. Nothing, no issue pertaining to finance can be dealt with without the finance as a party and without their stand being brought on record. No contempt lies. If finance is not a party and if they were not given an opportunity, absolutely no contempt lies. We'll close all contempt petitions. No contempt lies. And you please feel free to point that out to the court. If finance is not a party and the stand of finance is not brought on record, because the finance department has to deal with the finance.
Exactly.
They will have their stands. They will have to resist. If the court doesn't agree with their resistance, then a judicial order has to be passed. Otherwise, how are the finance department going to handle this? Hundreds of orders coming here and there. They are also managing the finance of the state.
Yes. Any
They are doing
areas.
their job. They are doing their job.
Yes.
You don't give them a fair opportunity to take a stand. don't give an answer to the issues, and then issue a direction, this will not be implemented. Cannot be.
Lordship is right, my lord. Regarding all these things, my
And
lord,
I'm not
every-
saying this to you,
Yes.
I'm saying this to learned members of the bar.
Every record goes to the finance department, and finance
They
department.
will
has to
not.
look into-
And
Yes.
as a judge, I think they have a justified point. If they
Yes.
were not heard, they were not issued notice, they are not in any way obliged to clear any finance file, even there is a court order.
And even then, they will not comply with.
Sorry,
This,
they will not comply.
yes.
And they are justified.
This, yes.
They are justified. They are the ones who have to manage the coffer of the state.
Once they will be present, my lord, they are bound to follow the court's order, my lord.
But then what is their view? The court has to know that.
Yes.
They may have a view. Without knowing that view, without giving them a chance, we are passing directions. This is not
Probably
fair
what
on the litigant as well as on the department.
Probably what the lordship has taken the view, my lord, that message should go, my lord. Otherwise,
No, people are not doing it. I can't comment, but
yes.
our coordinate benches are also passing orders, which is within their judicial
But,
discretion.
that-
I have nothing to say.
Yes, my lord, that.
All I'm saying is, after 3, 4, 5 years, these issues
That's
surface.
true, that's true.
And by that time, the litigant has suffered a lot.
Exactly, my lord.
The
And
litigant has suffered a lot.
whatever the good results come out, even then it is not implemented, my lord. And that's, and
Therefore, you must
had there
also,
been the present, my lord, then they will be bound to comply.
if they are present, if their
Yes.
views are taken note of,
That's true.
if they are given a chance to give their view, they don't give their view, then legal consequences will follow.
Yes.
But not by default.
Yes.
You don't make them party, no issue notice, don't give them chance to file affidavit, issue directions in motion stage and then come with contempt. This is not the way the court system can function.
My lord,
I am
in
very
such
clear about
cases,
it.
May I pray?
I invite people to argue contrary to it and convince me that this is how the court system should function.
My lord, for the welfare of these litigants, my lord, may I pray before lordships? My lord, this, what the lordships has taken the view, my lord. In the filing section, the message should go, my lord.
What filing?
My lord, what,
These-
why I'm saying, my
The
lord,
intellectuals are here, the learned members of the bar are there.
that's true, my lord.
Why should you go to filing section?
No, sometimes, my lord, again, my lord, for lacking of the finance department, my lord, or my lord, whatever the order will pass by this honorable court, sometimes litigants suffer because of not implementing, my lord. And
Most
this is-
most of the time. And I'm reiterating for the third time, it is not only impleadment. Finance has to get reasonable opportunity to respond.
That's,
Reasonable opportunity. Opportunity should be reasonable.
we have seen, my lord, most of the cases will go to the finance. Without having the approval of the finance, nothing can.
And they will not do it and they are not
Yes.
bound. They are not bound. I'm sorry to say, because you have to be reasonable. These people are getting bombarded with orders without getting a chance to give their stands. They have to manage the financial affairs of the state. The budgetary sanctions have to be made. There was a time when 1 or 2 orders is to come in 1, 2 years. Today, every day, 10s and 15s of orders are going. How are they going to manage all these things? So they are put to notice. All right, then they will have to make a way. But if they are not put to notice, how will they figure out how to do? So think about this thing amongst your colleagues also and see what is the best can be done.
Yes.
I am only suggesting and pointing it out that these things need to be looked into.
Lordship, whatever lordship is saying for the interest of the litigants, my lord.
Of course, what else? Who else's interest are we concerned with? Except the litigants. But they are also litigant. The
And-
finance is also a litigant here. We have to give them a fair opportunity.
And we are all here for litigants, my lord.
Absolutely. Litigant doesn't mean only petitioner. The government is also a litigant. And the courts have to be fair to both sides. All right, thank you for your understanding.
Obliged, lordship.
You too?
Yes. Lordship. The petitioner, the PM comes Sakita, he is serving the responsibility for last 24 years. On the basis of an inquiry report, the respondent number 2 has sought approval from the Secretary Corporation to start departmental proceedings for termination of service of the petitioner and to refer it to the investigation agency. The impleading order is page 44, Annex 9.
The same order.
Same order.
So there are similar orders. I think check it out. Mr. S.R. Gogoi and
Your Honor, I am appearing on behalf of Mr. Firas Kaur.
similar orders are there. Notice, yes.
There's an interim order, lots of pass.
Yes, similar order is there.
As well as.
My places. Here we are challenging in office memorandum at page 46. 47 is the operative part, madam. Forty-seven. 47 is the operative part.
Yes.
In view of the circumstances mentioned above, it has been decided that no cases for appointment on compassionate ground to the family member of the state government employees who died in harness or retired permanently on being declared permanently incapacitated for services or missing and whose whereabouts is not known prior to 31/3/2007 shall be entertained by the administrative department of so and so whatsoever for nor be placed before SLC.
So you are challenging this?
This matter.
We'll issue notice at this stage. That's all.
Similar matter.
Similar matters.
Similar matter pending.
Can you give the number, case number?
Not sir, that I have to check from the record also.
Okay, will it be possible for you to give him the number later?
Today I'll try also. Today itself.
Mr. P.K. Moni, learned counsel for the petitioner, also heard Mr. C.K.S. Burwal and G. Asam appearing for the state. By filing this writ petition, the notification dated 18/9/2024 issued by the government of Assam from a personal department, replacing the scheme of compassionate appointment with the scheme of within courts compassionate family pension with effect from 31/3/2017. No, 1/4/2017 has been put under challenge. Mr. Muni submits that similar writ petitions are pending before this court. Mr. C.K.S. Borua has prayed for some time to obtain instruction in the matter. Issue notice returnable in 6 weeks. Since Mr. Borua has appeared and accepted notice for all the respondents.
No, 1 to 5. 6 is held. 7 is also held.
1 to 5 and Mr. D.P. Boral and SC Health Department Assam has appeared to respond number 6 and 7. Service of notice is deemed to be complete in this case. Extra copies of the writ petition requisite in numbers be furnished to the learned department council. Let this writ petition be listed with WPC number so and so and the batch of other connected writ petitions.
In that page number 47, in that page number 47, what I think, Lordship, shall be, instead of shall be, it's on the not word is missing. Shall not, I think I just think.
Shall not
be entertained. Listen, shall be entertained is there, Lordship. I think the not word is missing in that.
Could be a typography. Yes.
Item 14 is also similar. Man.
Item?
Next.
Next is also same.
All right. 14.
Same party, same medical health department.
Yes, party is same. Only the district is different.
May it please.
Yes.
So I have assailed order of suspension. Your lordship will find at page 23 and excerpt 5. Now, the petitioner who was serving as ICU technician, but he was put under suspension for lodging of an FIR, and pursuant to that he was arrested and detained behind the bar for 40 days. Now, the authority, when he approached the authority after getting bail from this honorable court, the authority immediately put him under suspension with effect from the.
That's all right. What is his date of suspension?
Date of suspension is, my lord, it is with effect from 19/9/2023.
And the order was issued?
Order was issued on 20/12/2023.
Okay, so what is your grievance?
My lord, my case is that his, even after elapse of 90 days, his order, suspension order is not reviewed and no memorandum of charges has been.
I'll have to
given
take the instruction, lordship. Notice, lordship, at this.
Notice. Will issue notice 2 weeks. All right. Mr. M. Chaudhary and counsel appearing for the writ petitioner. Peruse the amendments made in the writ petition. The petitioner hearing who was working as ICU technician in the Mahendra Mohan Chaudhary Hospital at Guwahati was placed under suspension with effect from 19/9/2023, while order dated 20/12/2023 issued by the respondent number 3. By invoking the provisions of section 2, rule 6 bracket 2 bracket close of the Assam Service Discipline and Appeal Rules 1964. The grievance of the petitioner is that despite the lapse of more than 90 days and notwithstanding the fact that no charge sheet has been submitted against the petitioner, the order of suspension has not been reviewed till today. Hence, this writ petition. First of Mr. D. Upamanu, Learned Standing Council, Health Department, Assam, prays for 2 weeks' time to obtain instruction in the matter. Issue notice of motion returnable in 2 weeks. Since Mr. Upamanu has accepted notice for all the respondents, no formal notice, extra copies. List this case again on 16/12/2024 as a fixed item. Heard on the prayer of interim relief. The said prayer will be considered on the returnable date. The parties to come prepared accordingly.
I am obliged.
May I be Lordship. Lordship, the petitioner are serving in the Assam Rifle as a rifleman manner. The issue here is that whether the petitioner would be entitled for the old pension or new pension manner. As the recruitment process was notified in the year 2003. In the similar matter, my lord, this honorable court has issued the notice. So today I am praying for a notice only, my lord. I have a next that.
So according to petitioners, they are entitled to the old pension scheme.
my lord.
All right, take down. Heard Mr. Kumar and counsel for the writ petitioners. The petitioners herein are serving as what they are serving as?
Rifleman GD, my lord.
Rifleman GD under the CRPF.
Assam Rifleman.
Under the Assam Rifles and other paramilitary forces like the CRPF / BSF. According to the petitioners, they are covered under the old pension scheme. However, aggrieved by the decision of the respondents to subject them to the new pension scheme, both of them will be under courts, old pension scheme and new. The instant writ petition has been filed on the grounds stated in the petition. Mr. UK Goswami, learned CGC appearing for the respondents, prays for some time to obtain instruction in the matter. NOM 6 weeks, since Mr. Goswami has appeared and accepted notice for all the respondents. No formal notice, extra copies, list accordingly.
My lord. Much of lordship.
My pleasure, Lordship. Lordship, here the matter pertains to appointment in the Central Armed Reserve Police Forces. My candidature has been rejected on a non-existent ground. The medical board has declared me unfit due to mortal toe. That, my lord, there was no specialist available in the review medical board. Neither they took any opinion from a specialist doctor, and even in the general rejection ground, basically, the mortal toe is not an enlisted deformity itself, my lord.
Lordship, similar matters are fixed on 5th of December. I will produce the record on that.
5th of December?
My lord.
Yes. Heard Mr. B. Dekkal and B.M. Dekkal and counsel for the petition. Peruse the averments made in the writ petition. The petitioner is aggrieved due to rejection of her candidature, having declared her unfit due to, within quotes, Morton's toe, MORTON, supposed to guess as a TOE, Morton's toe. According to the petitioner, there was no qualified medical practitioner in the specialized medical board, in the medical board, so as to declare her as unfit. That apart, submits Mr. Dekker, there is no valid basis for the respondents to declare the petitioner as medically unfit. As such, the records be called for and the matter be examined. First, Mr. S. Roy, then CGC submits that similar matters are fixed before this court on 5/12/2024, and therefore this writ petition be also posted on that day. so as to enable him to produce the relevant records. Is it?
Yes, sir.
Issue notice returnable on 5/12/2024. Since Mr. Roy has accepted notice for all the respondents, no formal notice is required to be sent in. Extra copy of the writ petition will be furnished to Mr. Roy during the course of the day. List this case again on 5/12/2024 along with the batch of connected writ petitions. On the next date, the relevant records will produced for perusal by the court.
My lord, one post may be kept vacant, my lord, as
That order has not been passed anywhere. No select list. Prayer for interim relief will be considered on the returnable date.
my lord, obliged. That may be the option, my lord, if possible.
Yes, it is. Mention.
Much obliged, my lord.
You add that line. Prayer for interim relief will be considered on the returnable date.
My lord,
Yes.
in this matter also, my lord, OM dated 18/9/2024 has been challenged, like item number 13 and 14. Same matter.
So OM dated.
Lordship, here one thing is there. The petitioners are from various districts of Assam, Lordship. So they are in a single writ petition. Not.
So one government notification. Mr. N. Sharma, Learned Counsel for the petitioner. And who are for the respondents? They are appearing for all the respondents.
No, Lordship, except the Department of Sericulture, Lordship. All other
Members of the
respondents.
Learned Additional Senior Government Advocate Assam. For the respond numbers.
1, 2, then 5, 6, 7. 5, 6, 7. Lordship.
And Miss, your name please?
Oshi Sanna. Oshi Sanna.
Oshi. Numbers
4, 8, 9, and 10.
3, 4, 8, 9, and 10. Service complete. Rest will be same. 18, 9. Item
13, 14.
13 and 14, same.
Lordship, one writ petition only notice has been issued, Lordship, and we have 5067 of 24, Lordship, WPC.
WPC 5067.
67 of 24,
This
Lordship.
is to be tagged with that, huh? Earlier matter also.
That is bench 2 matter.
No, even it be, Lordship, the issue is similar. They have challenged the same notification, Lordship.
WPC number?
506724.
5067 of 2024.
Maybe bench 2, but this is of compassionate ground, Lordship. All the challenge.
Court will see. When
Yes, Lordship.
So in that there is a blank, no? List along with WPC also. This number you will put, yes.
Completely agree. Motion item 14.
May, please, my lord, I seek a lordship's leave to address to VC, my lord.
Yes, Mr. Chaudhary, what is it?
My lord, this writ petition, my lord, assails, my lord, the report of the one-man commission and the consequent actions taken, my lords, including, my lords, the departmental proceedings which have been initiated, and, my lords, the suspension of the petitioner. I mean, if I just give a background, my lords, the petitioner, my lords, participated in the APSC exam, my lords, of 2013-14. He was selected, my lords. He secured 11th rank in the category of superintendent of taxes. He was appointed, my lords. He was carrying on his duties, my lords. Excellent record. Now, what happens in, my lords, in 2019, a one-man commission is set up, my lords, headed by a retired judge of this court, my lords, 8 July 19. Now, my lords, that commission of inquiry is set up, my lords, under the Commissions of Inquiry Act 1952. Now, my lords, what happens is when the commission, my lords, finds material, my lords, against this particular candidates, my lords, who had taken the examination, the commission issues notice, my lords, by an order of 21st June 2021. First, my lords, please have the commission of inquiry appointment at page 83, my lords. And the issue is this, my lords. The issue is the commission, my lords, decided to inquire into the conduct of the petitioners. And when you inquire into the conduct of the petitioners under 8B, your lordship knows, my lords, a reasonable opportunity of hearing has to be given, my lords. The person has to be allowed to appear before the commission. He should be allowed to cross-examine witnesses. He should be allowed to participate in the proceedings, and he should, my lords, be also allowed to be represented by a legal practitioner. Now, my lords, all this has not been done. What happened, my lords, is this, my lords. First, have the commission of inquiry, my lords, notification at page 83. It's a very short issue, my lords. Your lordship knows, my lords, that if you don't comply with 8B and 8C, the entire proceedings, my lords, are non-est and void, including the consequences proceedings. Just have page 83, my lords. The lordships will see right at the top, in exercise of powers, this is Annexure Act, my lords.
in exercise of powers conferred under Section 3 of the Commissions of Inquiry Act 1952, the Governor of Assam is pleased to appoint a one-man inquiry commission headed by Justice so-and-so retired judge of this court to inquire into the allegations of anomalies and malpractices in conduct of examination. Now, my lord, the Honorable Commission at page 90, my lord, passes an order. Just have that order. Annexure J, my lord.
Yes.
As recorded in the order of 1906, during the course of inquiry, please mark, and upon scrutiny of answer scripts of the examination in question deposited in the court of the learned special judge Assam, certain discrepancies have been found in respect of actual marks secured as per the answer script, but shown secured enhanced marks in the final tabulation set. In view of the above, please mark, each one of such candidates, as the records would reveal, is required to be issued notice asking to explain the position. Accordingly, let such notice be issued detailing the facts of each one of such candidates. Secretary of Commission is authorized to issue the notice in the format prescribed. Now, the notice your lordships will have is at page 88, 2 pages prior, my lords. Whereas the government of Assam, so have the second paragraph. Whereas during the course of inquiry and upon scrutiny of the answer script of the successful candidate deposited with the learned special judge Assam in connection with special case number so-and-so, certain anomalies have been found between the actual marks secured in the answer script and the marks secured in the final list in respect of such candidate. And whereas you also appeared in the CCA 2013 in roll number so-and-so, got selection in the final list, the anomaly cited above pertains to you in respect of the following subjects. So when the notice is issued, well, the petitioner submits a reply, my lords. That reply is at page 92 on 12/7/2021, saying that we do not know, my lords, who are this person. We have taken our examination on merits. We have no involvement in any of the anomalies. Now, my lords, after this, nothing is heard from the commission. And my lords, on public media reports, my lords, report came to be submitted. That report, my lords, castigated my client, including my lords, others around 32 or 40 of them, my lords. And pursuant thereto, my lords, on 30th November 2023, an order is passed putting the petitioner under suspension and my lords, initiation of disciplinary proceeding. That order, that suspension order, your lords will find it at page 46. Page 46, my lords, the impugned order, my lords. And it all flows from the recommendations and findings of the one-man commission. Whereas the one-man commission of inquiry has reported about anomalies and malpractices resorted to for the selection of candidates in exchange of so-and-so and other expeditious consideration by Assam Public Service Commission headed by the chairman Sri Rakesh Paul while conducting the combined. And whereas it has been reported that Jayanta Doloi, that's the petitioner, was a beneficiary of the anomalies and malpractices carried out by APC. He got recommendations by APC for appointment of so-and-so. Now, just pause here for a moment and please have 8B. Because, my lords, your lordships knows, my lords, the law is well settled. Your lordships knows, my lords, Kiran Bedi versus Inquiry Commission. Then there is State of Bihar versus LK Advani. Those judgments says that if you don't comply with 8B, it's a valuable safeguard. The entire proceedings are void, and including all consequences.
Mr. Chaudhary, you are before this court challenging what?
I am challenging, my lords, the report of the one-man committee, my lords, all recommendations finding. Just have my prayer, my lords, at page 38. I have challenged, my lords, the report of the one-man commission, saying that, my lords, the findings insofar as it concerns the petitioner, my lords, are illegal, void, and contrary and hit by section 8B. Just see page 38, my lords. Declaring, adjudging the proceedings before the Commission of Inquiry relating to the affairs of APSC. I'm sorry, my lords, page 38.
Page 38. Where is the one-man committee?
Yes, my lords. Of the report is not there, my lords. We have not been disclosed till now. We have not been given the report. We have not been given the findings. Now, what happens, my lords, is along with the suspension order, my lords, a confidential letter is given to us that your lordships will find, my lords, at page 95. Just have page 95, my lords. The confidential report is there, my lords, at page 95. And at 97, if 98, if your lordships come, chapter 10, 11 of the report is enclosed. Just have chapter 11, at 98. We fall in category 2, that category 2 starts from page 107.
Yes.
107, if your lordships have, further anomalies.
Yes.
Further anomaly malpractices found by the commission during the course of inquiry against the other candidates who are still in service. And please turn to 112, I am serial number 15, Jayanta Duloi. Now, serial number 15, Jayanta Duloi. Now, the contention is this, your lordships will appreciate it. That under 8B, if you issue a notice, you are inquiring into the conduct of a person, then the commission is duty bound, to give notice under 8B. And once you give a notice under 8B, then you have to, give an opportunity of hearing to the person concerned.
Is it 8B or 8D?
8B.
I'm trying to understand
8B.
what you're saying. There is a bit of
8.
disturbance, but anyway.
I'm sorry, section 8B, 8B, B for Bombay.
B for Bombay.
Yes, just have the
8B of
the Commissions of Inquiry Act 1952 and 8C, 8B and 8C. Two provisions will make it extremely clear, as to what the commission should have done. Just have 8B, The lordships has?
Yes.
So persons likely to be prejudicially affected to be heard. If at any stage of the inquiry, the commission considers it necessary to inquire into the conduct of any person, or is of the opinion that the reputation of any person is likely to be prejudicially affected by the inquiry. I pause here, On 21st June 2021, when the commission issued notice to me, it was inquiring into the conduct of the petitioner. Now, please read further. The commission shall give to that person a reasonable opportunity of being heard into inquiry and to produce evidence in his defense. And 8C says, that here I have a right to cross-examine the witnesses, I have a right to address the commission, and I have a right to be represented before the commission by a pleader, legal practitioner. None of these safeguards, have been followed by the commission with due respect, rendering, the report and all consequential proceedings, susceptible to challenge, and the law is, that the proceeding stands vitiated. If I may just quickly, give two decisions of a court. Today, for the purposes of interim relief, my submission is this, Now, departmental proceedings have been also initiated against the petitioner. Insofar as the report is concerned, in another writ petition, WPC 5862 of 2024, this court has issued notice, on 13/11/2024. That order, your lordships will find in Annexure U, page 151 to 153. The additional affidavit with my learned friend, Ms. Chaudhary, filed today, with the lordships leave. Now, today, for the purposes of interim, what I'm saying is this, your lordships may keep this matter along with the other matter on 6th December, In the meanwhile, what I'm saying is that your lordships have already stayed departmental proceedings where other candidates who had come before your lordships only on the ground that criminal proceedings and the departmental proceedings should not go together. It should await the outcome of the criminal trial. That order your lordships have passed, That your lordships will see at page 138, your lordships order,
When was the departmental proceeding initiated?
It was initiated on 30th November 2023 by a notice.
And after
then, 11 June 2024, I appeared, I submitted a detailed reply. Thereafter, nothing was heard. And after, this earlier writ petition was filed on 16th November 2024, page 53, just have page 53. Now, a notice is issued that you come and appear before us on 24th, Sorry, on 26th of November, page 53, So all I am saying today, for the purposes of limited interim relief, because my interim relief, your lordships will consider on 6th December, when, the entire report comes before your lordships, whether 8B and 8C has been complied with. Today, I am seeking, my lord, the limited interim protection, which your lordships have granted, my lord, at page 138.
That's right, but in your case, the proceedings were initiated 1 year back. In those cases, they came immediately.
No, my lord. Same proceeding. These are all similarly situated officers, my lord, all castigated by the one-man commission. Now, your lordships have said that since criminal trial is ongoing, the departmental proceedings must await, and that's your lordship's order at 138. Just have that order, my lord. And there is a coordinate bench judgment order of justice Medhi also, my lord, granting the same protection to similarly situated. So today I am saying, my lord, your lordship sees the record of the commission, my lord.
Yes.
This interim protection may be granted.
Lordship, here the commission report will be with the personnel department. I'm representing the taxation department where the petitioner was working. Hello.
He says there is a criminal proceeding going on the same set of facts, and there are other interim.
Similar such thing.
Then similar order has to be passed through.
Lordship, already this has been taken up with the government lordship. We are yet to come up with the.
That is all right.
separate
But what do you say about the prayer for interim relief? That interim relief.
Only limited to them.
But Mr. A. Chaudhary, learned senior counsel, assisted by Ms. B. Chaudhary, learned counsel appearing for the writ petitioner. Also heard Ms. M. Bhattacharjee, learned additional senior government advocate Assam, appearing for the respondent numbers 1.
One lordship, I am.
Respondent number 1, Mr. B. Chaudhary, learned SC, Taxation Department, Government of Assam, has appeared for the respondent numbers 2, 3, and 4. Full step. By filing this writ petition, assailing the departmental proceeding initiated against him, wide notification dated 30/11/2024, the petitioner has approached this court inter alia contending that the departmental proceeding is completely vitiated since the same has been based on a report of the one-man inquiry commission, which was prepared in complete violation of the provisions of sections 8B and 8C of the Commission of Inquiry Act, 1952. Full stop. It is also the submission of Mr. Chaudhary that since the departmental proceeding is based on the same set of facts, similar charge, and sought to be established by examining similar nature of witnesses. Hence, similar nature of witnesses involved in a criminal proceeding which is going on simultaneously. Hence, for the ends of justice, the departmental proceeding be stayed till conclusion of the criminal case. Full stop. In support of his above argument, Mr. Chaudhary has invited the attention of this court to similar orders passed by this court in other similar writ petitions, wherein the departmental proceeding has been stayed till a response of the state government is filed in the matter. Mr. Chaudhary, learned Standing Counsel, Taxation Department, prays for some time to obtain instruction, file affidavit. Ms. M. Bhattacharjee, learned Government Advocate, Additional Senior Government Advocate, Assam, has submitted that since a number of writ petitions raising the same issue is pending before this court, wherein an interim order is operating, the government is examining the matter with all seriousness, and therefore some time be granted to obtain instruction and file affidavit. The learned senior government advocate has, additional senior government advocate has, however, admitted in her usual fairness that interim orders are operating in similar writ petitions, wherein the very further proceeding in the departmental proceeding has been stayed. First of, in view of the above, issue notice of motion returnable in 3 weeks. Since the respondents are already represented, no formal notice is required to be sent in this case. Extra copies of the writ petition will be furnished to the learned departmental counsel, requisite in numbers, within a week from today, so as to enable them to obtain instruction. On the request of learned counsel for the parties, let this writ petition be listed along with WPC number so and so and the batch
5862 of 2024.
5862
2024.
and the batch of connected writ petitions. Stop. Heard on the prayer of interim relief, the said prayer will be considered on the returnable date. However, as an ad interim measure, it is hereby provided that the departmental proceeding initiated where the writ petitioner by notification dated 30/11/2024 shall remain suspended till the returnable date.
Grateful. Your Lordship kindly call for the records of the one-man commission and the report. That will clarify. On the next step, let it be kept handy. Your Lordship will just observe that.
The inquiry by the finance department only, no home department is not there. Lord.
Departmental inquiry.
Yes.
Yeah.
Yes, by the.
Departmental inquiry initiated by the writ petitioner by notification dated 30/11/2024 shall remain suspended.
23, man.
23/11.
Yes, 30th November 2023.
Acha, 30th November 2023.
Yes. I'm only requesting if your Lordship can call for the records of the one-man committee. That will clarify 8B, 8C complaint. That's the short point.
Look, they will bring it on the next day. You wait.
Your Lordship will just observe that. Let the report be kept ready.
No, but supposing they don't produce it for next 2 years and you get an interim order, what is your problem?
My problem is this, my lord. Every day, my lord, based on the report of the commission, my lord, I have been suspended, my lord. My suspension is continuing, my lord. We are going through an extreme penury, my lord. And it's all based on the report. That report will clarify everything, my lord. That's why I'm saying that, my lord.
The one-man commission inquiry report
and the records
before the court on the next date fixed. Yes.
I'm grateful, my lord. Very grateful.
May it please your Lordship. Lordship, we are for the opposite party, the IA, which I pray for some more time to file a response, Lordship.
Yes.
That otherwise case is ready for hearing. Let them file the response along with the main counter also, so that it can be taken up a final hearing on the next date, Lordship.
The IIT has filed this application.
We have filed an IA, Lordship.
That's right.
To file a rejoinder to the IA.
Lordship.
You are appearing for the writ petitioner.
For a writ petitioner, Lordship. Opposite party in the IA, Lordship.
We filed a counter also in the writ petition. Let them file rejoinder to the, if they desire to counter also as well as to the IO, so that matter can be taken up and finally disposed of.
Lordship.
On a fixed date.
How much time you
Lordship,
want?
10 days time may be granted. Lordship.
That
Right,
date will be fixed, Lordship. In that case.
Senior counsel listed by Mr. Day and counsel appearing for the applicant. Also heard Ms. P. Barua, learned counsel appearing for the OP stroke writ petitioner who submits that 10 days time be granted to file counter to this IA. First up, responding to the above, Mr. Kakuti submits that he would have no objection to the said prayer, but since affidavit in opposition has also been filed in the writ petition, and considering the urgency involved in the matter, an attempt be made to take up the IA along with the writ petition for final disposal on the next day. The petitioner's counsel has agreed to the said proposition. In view of the above and on the request of learned counsel for the parties, this matter is directed to be listed again on 17th of December 2024 as a fixed item. So as to enable the parties to complete pleadings. Interim order passed earlier to continue till then.
Yes.
Deeply obliged.
For admission, item 20.
Last occasion, government advocate has taken time. And Lordship, as per my knowledge, the prayer made by the petitioner is under process and a department. So Lordship made this matter on January.
Mr. S.K. Goswami, learned counsel for the petitioner, and Ms. R.M. Dekar, learned standing counsel, Water Resources Department, Assam, have both made a request to post this writ petition again in the month of January 2025 by submitting that some action is being taken in the matter at the departmental level. Prayer allowed, list accordingly.
Obliged.
Obliged.
Item 22.
Please, your Lordship. Matter is regarding, my lord, the stepping up of the pay of the petitioner. Lord, what happened, my lord, in the year, my lord, 82, he was appointed, and in the year, my lord, 95, he was promoted to the post of UDA.
Thereafter, my lord, some of his juniors were promoted in the year, my lord, to 1996. And they have been given, my lord, pay at the rate of rupees, my lord, 4,720. And to equalize that, my lord, in the on 23/12/98, my lord, the Deputy Commissioner Gulaghat, he has passed an order.
1 minute, yes.
Lordship has seen the instruction possibly, Your Lordship, just after the orders, there is an instruction placed by my friend from the JAD. Wherein
Finance department is a necessary party. I think my lord, finance.
name has not been, they have been impleaded, Your Lordship, cost title has also been filed, but name has not been reflected, Your Lordship. Otherwise, their stand would be necessary considering the instructions being placed. Para 5, Your Lordship, may see in the instructions.
Finance,
Finance, I have.
you are appearing. Mr. So-and-so for the petitioner, Mrs. C.S. Hazarika Leonard G. Assam and Mr. A. Pukon Leonard Standing Council
For response
GAD are present. Mr. H. Solia Leonard Standing Council Finance Department submits that neither any copy has been furnished to him nor is the name of the Leonard SC Finance reflected in the cause list, as a result of which he does not have any instruction in the matter. Mr. Saika assures this court that a copy of the writ petition will be furnished to, extra copies of the writ petition will be furnished to Mr. Cholia within 2 days from today.
During the course of the day.
During the course of the day. In view of the above, let this writ petition be listed again after 10 days by reflecting the name of Mr. H. Cholia, Leonard SC Finance in the cause list.
Lordship, they fix a date, my lord.
10 days.
Published.
May I appeal, Your Lordship? My lords, kindly to page 32, my lordship.
Lordship, your instructions are awaited, your lordship. I need some more time.
Page 32, my lordship.
Yes, you want payment of
House rent allowance, my lordship. As per order dated 8th March 2019.
So she wants some time, some more time to apply. I heard Mr. S. B. Lashkolani, counsel for the writ petition. I also heard Ms. R.M. Deka, Leonard Standing Council, Water Resources Department, Assam, and Mr. H. Olia, Leonard SC Finance, who pray for 4 weeks further time to obtain instruction in the matter. Prayer allowed, let the writ petition be listed again after 4 weeks. 4 weeks. Yes, every case you want a date, huh? No adjournment will be given thereafter. You want date, and when the matter is fixed, then you want adjournment. This is what is going on. No.
But some time we will give it to file affidavit, my lord.
Lordship, affidavit will be required, Lordship. May I
Heard
request-
Mr. A. Tavila, Leonard Counsel for the petitioner, on the request of Mr. S.K. Medi, Leonard CGC appearing for the respondents, 3 weeks further time is granted for the respondents to file affidavit. List this matter again in the 2nd week of January 2025. Yes,
Lordship, may I pay for a date because it's a pension matter, Lordship. My lord,
I have given it already.
2nd week of January.
January.
And Lordship, at this stage, Lordship, I have a simple prayer here, Lordship, that he has been discharged on superannuation, but that superannuation has not been notified till date by the authority. So that because of that not notifying his superannuation, Lordship, he could not appear for apply for Lordship in civil, Lordship. In
Well, already
private
from army already retired, my lord. Then subsequently armed force tribunal, my lord, he joined, my lord. That
On the next date fixed,
Yes.
Mr. Mehdi to also produce the order of, produce the notification
notifying.
of superannuation of the petitioner from service issued in accordance with the rules.
My lord, from armed force tribunal, my lord.
Huh?
Armed force
By the
tribunal.
authority.
From
By
the
the-
Armed Force Tribunal.
Yes.
Retirement from which place?
My lord, already,
Armed
my
force
lord,
tribunal.
my lord, initially from army, he already retired, my lord. Subsequently joined armed force tribunal, my lord.
From the Armed Force Tribunal.
Yes.
Yes.
I can tell
I'm
you.
like that.
Lords, in this case, my lord, person has been transferred without any consent to the BTC. In the meantime, my lord, from the period of 1st January 2024 to August, the 8-month period, he has not received the salary. Like in the meantime, my lord, the process is on to post facto approve it and then release the payment. Also, we'll post it after 4 weeks, my lord. In the meantime, the formalities will be conducted, my lord, the BTC.
Lordship, 4 weeks too long.
All right, your name, please?
are they appearing on behalf
Ms. R. Dev, Learned Counsel is present for the petitioner. Mr. S. Bora, Learned Standing Counsel, BTC submits that in order to facilitate release of the salary of the petitioner, necessary steps at the departmental level has been initiated for granting ex post facto approval for the
transfer order so that
transfer order in question, so that the salary of the petitioner can be released. As such, Mr. Bora has prayed for posting this matter again after 4 weeks so as to enable the formalities to be completed. Ms. S. Sharma, Learned SC, Health Department, Assam, is also present and does not have any objection to the same prayer. In view of the above, let this matter be listed again in the second week of January 2025 as a fixed item.
of last Mr.
For orders, item 27.
May it please your lordship. Lordship will kindly have the order dated 27/8/2024, my lord. 4 issues basically. One is with regard to the number of disposals. Second is library facility. That is, my lord, the subscription of journals. Third is departmental mechanism for the members. Fourth is, my lord, extension of service. Fourth, serial number 4 is already, my lord, done. Serial number 4 has already been, my lord, done. Extension has come. So far as serial number 1 is concerned, number of disposals, my lord, I have prepared a chart and filed a report. Lordship will have a look that the numbers. There are tribunals wherein, my lord, the number of disposal is very less. In, say, for example, in Tamulpur, the pending case is 2595 and disposal that your lordship wanted for last 6 months, that is 41. And so far as Udalguri 1 and Masbat is concerned, the pendency is 4988 and 4498 respectively, and disposal is 118 and 40. So the number is very less. In that even, my lord, perhaps my submission would be that the state is to take a call as to why the disposal is so less, or circulate a questionnaire among the members to ascertain the reasons for this seriously less disposal, my lord. That is, my lord, my humble submission with regard to serial number 1. So far as serial number 2 is concerned, regarding library facility, my lord, their contention in their affidavit is that, my lord, no request has been made by any other of the members for the journal. Now, that is not correct. These are 2 applications made by 2 members to the state government praying for journals. And in fact, your lordships on the last occasion, my lord, expressed that what is the requirement for the members to ask for journal, because it is the duty of the state to provide the journal so that they can get the update of the legal position in these matters. There are 2 communications. One is recent and another is, my lord, 2022 and 2024. So journals were there till 2019. Thereafter, state has discontinued providing the journal. Now the third issue is the interdepartmental mechanism to look into the grievances. The state in their affidavit has come up that there is no internal mechanism, my lord. Apart from that, one issue with regard to Chirang has come up. Chirang.
Yes. So what is to be done today?
Lord, today, my Lord, there has to be some specific stand with regard to this providing the library facility, because this issue cropped up in the month of August 2024, and we are in November. Till date, they have filed affidavit saying that there is no prayer made for supplying of the journals. But that is absolutely incorrect.
Yes, Mr. Majumdar.
Affidavit. The first one is about the disposal rate of the tribunal. There is a lot to see from the some of the foreigners tribunal, may not the disposal rate is low, but in others it is not as low as in the FT of Tamulpur and all. So for that, I'll leave it to Lordship what direction the Lordship proposes to pass.
What direction is, see, there is no need for direction. Why don't you on your own come up with some suggestions? There is a, do you think that some refresher course, etc., will be necessary here? Or is it necessary to shuffle the officers? Some suggestion you should make apparent. Huh? If there is a problem.
What is
in
the
some
exact
place-
problem that has to be identified? Today, I've seen this number of disposal has been given. And then what is the exact problem? What is the problem being faced by them in not being able to dispose of cases?
You have
That
to
will
do it. This court will not go into that.
Lordship may pass the order. We'll find out what is the reason for this low rate of disposal, and then appropriate measures. to be
What
taken.
about item number 2, proper library facility? This is for the department to assess. Why is it that?
Here, my lord, yes, minimum 1 or 2 journals can also be provided. Only one issue may crop up here. In some of the tribunals are functioning in a rented accommodation. To what extent they will be able to, my lord, store the books, whether they have enough space or not, that has to be ascertained, my lord. Lord may pass some order depending on the nature of accommodation they have. At least minimum 1 or 2 journals can always be provided. That not actually, because this is minimum thing they need. That I'll leave it to your lordship. In this way, it can be taken care of.
And what about number 3?
Number 3, my lord. My suggestion, I can only suggest, my lord. Possibly, my lord, the registry of this on the court, along with the departmental secretary, they may sit together to find out as to what is to be done, because they are not in normal service of the state. Yes, they are in a different stream altogether. So for
So
that,
the
they can
discipline and appeal rules and all these things will not be applicable.
normally. So if your lordship passes an order, they will see if the government passes an order applying those discipline appeal rules also to them, then the matter may be slightly, let them explore, my lord.
This is with regard to, my lord,
Their grievances.
Their grievances, the members and the staff, because repeatedly this court or the registry is, my lord, receiving communications that we have got this problem, that problem. So to meet.
But one more thing, why do they have so much of grievance? What is the mechanism for
Not
other
that
employees?
much, my lord, not that much. They only send when, like Chirang lordship has seen, my lord, that there is serious infrastructure problem there. Only those cases comes. Otherwise, my lord.
So we'll ask them to rotate through the registered judicial of the High Court.
Yes.
Who will take appropriate decision in the matter.
Yes.
We'll forward it to the Home Ministry and try to sort it out.
Yes.
That will be the mechanism.
Man.
All right, take down. I heard Mr. H.K. Das, learned amicus curiae, as well as Mr. A. Das, learned amicus curiae, appearing in this read petition. Also heard Mr. D. Majumdar, learned Additional Advocate General Assam, appearing for the state. Mr. S. Dhar, learned Registered Judicial of the High Court is personally present. Uh, This matter has been listed today in terms of the order dated 4/10/2024 passed by this court. Full stop. Earlier, on 27/8/2024, this court had passed an order seeking the response of the state with regard to the 4 queries stroke issues, which are as follows. 1, 2, 3, 4, you quote it from here. Full stop. Insofar as the query number 1 pertaining to low disposal rates, pertaining to disposal of cases is concerned, it has been noticed from the figures furnished by the state that while in some of the foreigners tribunal, the rate of disposal of cases is satisfactory, in some foreigners tribunals, it is very low, full stop. The reason as to why the rate of disposal of cases is very low in those stations is not apparent, full stop. Mr. Majumdar, learned additional AG Assam, however, admits that these are issues that will have to be looked into at the departmental level, and remedial measures as may be necessary will have to be initiated so as to ensure that the rate of disposal of cases is in consonance with the rest of the state. First of if that be so, the respondents may look into this issue and come up with remedial measures so as to improve the situation. Stop. Insofar as the suggestion in serial number 2 pertaining to the library facility is concerned, here also, the learned additional AG submits that it will be fair to suggest that some journals should be made available to the learned members of the foreigners tribunal. However, since a few of the foreigners tribunals are functioning from rented premises, it will be necessary to examine whether proper storage facilities for retaining the books are available. Full stop. Mr. Majumdar therefore seeks some more time to look into the said aspect of the matter before issuing a formal order in this regard. Full stop. The said request appears to be reasonable and therefore is accepted by this court. Full stop. Insofar as the lack of departmental mechanism to look into the grievance of the individual members of the foreigners tribunal and the working staff under query number 3, Roman 3 is concerned, it is submitted at the bar that all such grievances can be routed through the registered judicial of the High Court, who would then process the same and forward it to the Home Department. Stop. Mr. Majumdar submits that the aforesaid mechanism would be adequate for the time being. Stop. The learned amicus curiae is also in agreement with the said suggestion. In view of the above, it is hereby provided that individual grievances to complaints, if any, of the members of the foreigners tribunal and the staff working therein shall be forwarded directly to the registered judicial. On examination of the same, if the complaints are found to be reasonable, the same may be forwarded to the concerned department with necessary recommendation. The Home Department to issue a notification to that effect at the earliest. Full stop. Insofar as the issue number 4 is concerned, it is submitted at the bar that the necessary orders of extension of service of the members of foreigners tribunal have already been issued by the state government, and therefore the said issue stands resolved. For the reasons stated here and above, let this matter be listed again on.
Like in January.
Yes.
Because individual report will have to sort from the members of the tribunal as to what is the problem they are facing. Oh.
When do you want it?
It was 6th or 7th.
7th of January 2025. So as to enable the learned state council to obtain necessary report and place before the court.
Also will observe something with regard to Chirang, or my senior will take
No,
Chirang.
that he will process it.
Mine. That will be. Notes. Highly, deeply.
May I please, Your Honor, this matter is infructuous.
Infructuous.
Yes, also. Already petition has been declared.
Okay, you are Mr.
P. Sohria.
Mr. P. Chaudhary, learned counsel for the petitioner.
Sohria also.
Mr. P. Sohria, learned
Yes, sir.
counsel for the B. Sohria, learned counsel for the petitioner, submits that the writ petition will become infructuous and therefore the same be closed. Miss
Y.A. Kunyak on behalf of MD Bora.
Ms. M.D. Bora, learned counsel for the respondents is present. On the submission of the petitioner's counsel, this writ petition stands disposed of as infructuous.
May I observe also, Lordship, the matter into non-compliance with order dated 13/3/2023. As by this honorable court in WBC number 1320 of 2023. The order is at page 10, Lordship.
Order has been complied with.
No, Lordship.
Lordship, I am returning response number 5, Lordship. Yes, Lordship, on my part, Lordship, we have filed affidavit, we have complied order with. Our part is only to Lordship forward the application submitted by this petitioner to the director. That we have done, Lordship.
So
They have
who has not complied with the order?
Lordship, the contemner 1 and 4. Direction was given to the director, Lordship.
They are still in contemner 1 and 4.
Lordship. Their name shown in that was this, Lordship. Page 11 is the operative portion.
Why they are not present today? Heard Mr. N.G. Gogoi, learned counsel for the petitioner. Also heard Mr. J. Kalita, learned counsel appearing for the respondent number 5, who submits that the order of the court insofar as his client is concerned has already been complied with. Full stop. The learned counsel for the respondent numbers 1 and 4.
1 and 4.
1 and 4 are however not present before this court today, although the name of the counsel have been duly reflected in the cause list. First of all, under the circumstances, this court would be left with at the same time, the order of the court has also not been complied with till today. Under the circumstances, this court would be left with no other option but to direct personal appearance of these officers. However, for ends of justice and in order to give one more opportunity to these respondents to appear in these matters, this writ petition is directed to be listed again on 3rd December 2024 as a fixed item. It is made clear that if the respondents remain absent even on the next date fixed, consequential orders will follow.
Item 35.
But I have instructions to appear on behalf of respondent number 1 and 4, my lord. But I pray for 4 weeks time, my lord. In the meantime, my lord,
How much time?
4 weeks time, my lord.
4 weeks time for what?
My lord, in the meantime, my lord, the state is preparing an appeal, my lord. We are in the process of filing the appeal. It will be filed today, my lord.
Appeal against which order?
Against the order dated 6/6/2024, my lord. In the contempt petition order is at page number 14. It starts at page number 14, my lord.
Yes, heard Ms. R. Dekar, learned counsel for the petitioner. Also heard Mr. D. Nath, learned counsel appearing for the respondent numbers
1 and 4.
1 and 4, whose And Mr. S. Datta, learned counsel appearing for the respond numbers. Respond number 2. Mr. Nath submits that the state has decided to prefer an appeal against the order dated 6/6/2024 passed by the learned single judge in WPC number 4879 of 2020, and therefore this matter be adjourned for 3 weeks so as to enable him to obtain updated instruction. Prayer stands allowed. List the matter accordingly.
Item 36.
Meet please, Your Lordship.
Yes.
Lordship, the IA is for the release of the provisional pension which was not paid from February to May. Lordship. Respondent authorities suddenly stopped the provisional pensions.
Yes. Why it has been stopped?
Lordship, there was this defect which is there anyway in the order also it was reflected. There was this problem with the birth certificate. He had given a birth certificate with 3 or 4 different birth certificates, Your Lordship. Therefore, ultimately, Your Lordship, this provisional pension has been granted at this page number 38 in the IA, Your Lordship. Sanctioned at least, Your Lordship. Page number 38. The thing is that, Your Lordship, there were because of that the entire issue is because of this only, Your Lordship. And right now, if I'm not wrong, provisional pension has been released.
I don't.
If I'm not wrong, because page number 38, Your Lordship, there was a problem with the amount of provisional pension being released because of this thing, and this page number 38, Your Lordship, provisional pension has been sanctioned, Your Lordship, by the Labour Commissioner, Your Lordship. Is able authorized to amount disbursed the same. The expenditure is debitable. That is page number 38 of the IA, Your Lordship. This is the sanction order, Your Lordship, office order, Your Lordship. Because there were some there was some problem. Even now, this situation is there, and maybe this.
So you obtained instruction then.
Lordship.
What has happened? Heard Mr.
SRA Nasir. SRA Nasir on behalf of
counsel for the applicant. Also heard Mr. C.S. Hazarika, learned G. Assam, as well as Mr. C. Borua, learned standing counsel for the AG Assam, appearing for the opposite parties. This IA has been filed seeking a direction from the court for release of provisional pension to the petitioner, which according to the applicant petitioner was suddenly stopped by the authorities. First up, responding to the said submission, Mr. Hazarika submits that due to some discrepancy in the multiple birth certificates relied upon by the applicant, there was some anomaly in the figure of provisional pension, as a result of which there was a temporary disruption of the same. However, by referring to the order dated 29/5/2024, passed by the Labour Commissioner Assam, Mr. Hazarika submits that to the best of his instruction, as per his instruction, now there is an order for release of provisional family pension. Therefore, therefore, full stop therefore, there may not be any necessity to issue any order in this IA. Responding to the above, the applicant's counsel 10 days time to obtain updated instruction. Let the matter be listed accordingly. Let the matter be listed accordingly.
Lordship, I said release of provisional family pension. Also, here the order is sanctioned. So sometimes sometimes this discrepancy comes up, and then
Lordship, the birth certificate was submitted by the husband of the petitioner.
You check it out.
Lordship.
Item 37.
Highly obliged.
May please, Your Lord. But in this matter, my lord, there was a mistake in taking steps, my lord. We were to take steps by way of registered post. We took by way of usual process, my lord. We'll do, my lord, do the needful. My lord.
All right. The learned counsel for the petitioner submits that due to an inadvertent error, steps in this case was taken by usual process instead of registered post. However, having realized the mistake, the petitioner's counsel seeks 3 days time to take steps by registered post with AD. For service of notice upon the respond number?
6.
Mr. R.R. Gogoi, learned standing counsel, PHE Department, Assam, is present on behalf of the respond numbers 1 to 5. List the matter again with appropriate office number.
Highly.
Item 38.
Item number 38, we had preferred this application, saying that they were deducting the maintenance from my salary even after the divorce had been granted to me from my wife. statement is made, my lord, that the, from July, it has been stopped, the reduction. I can be closed, my lord. The writ petition may be taken up for hearing at a convenient date, my lord, any convenience.
My lord, pursuant to the application submitted by the petitioner on 22 June 2024, we discontinued the maintenance from July.
All right, you take down, heard Mr. R. Majumdar, learned counsel for the applicant, also heard Mr. A.K. Datta, learned CGC appearing for the opposite parties. Stop. This IA has been filed by the applicant writ petitioner, entirely contending that even after the marriage of the applicant with his estranged wife was dissolved by a decree of divorce, maintenance component is being deducted from his salary, first up. On 29/10/2024, when the matter was called up before this court, the following order was passed, quoted. Mr. Majumdar submits that since the deduction of maintenance component from the salary of the petitioner has been stopped, this IA may be closed. Taking note of the submission of Mr. Majumdar, this IA is hereby closed. Yes.
I'm obliged.
Writ petition, you write, let this writ petition be listed for hearing. You write in the writ petition, so-and-so for petitioner, so-and-so for the respondent. The writ petition has been admitted.
Yes,
the writ petition has already been admitted and the parties are already represented as such. Register to list this case for hearing in usual course.
Obliged.
Your Lordship has directed on last occasion why the scale of pay was not extended to the petitioner, junior engineer, serving in the municipal board, my lord. The respondent 7 is the chairman, my lord. And they have already, executive officer already filed the affidavit, my lord. The only Lordship, limited issue.
I'm sorry to say, Lordship, I've already talked with the concerned person. He's saying that some time is required because they have already prepared all the data. And the inconvenience on their part is that this annexure 10, Lordship, if your Lordship kindly see page number 41. In that particular communication, they made a prayer before the Director of Municipal Administration with regard to the resolution taken to pay salary as per the scale in following way. But since thereafter, Lordship, there was no such direction or the instruction on the part of the concerned authority with regard to the payment, who will make the payment, because the authority was.
We'll give you another 7 days time. How much? 10 days?
7 days will do, Lordship.
7 days is fine.
Seven
So
days
after
will-
10 days, we'll fix it on 5th December.
5th December.
Mr. B. Borwa, learned counsel for the petitioner, is present and has invited the attention of this court to the order dated 7/11/2024. Mr. S.P. Chaudhary, learned counsel for the respondent numbers
4 and 7, Lordship.
4 and 7 submits that despite sincere efforts, necessary instructions could not be obtained by him since the relevant data could not be collected by the authorities in the meantime. However, Mr. Chaudhary submits that within a week's time, the affidavit on behalf of his clients will be brought on record.
On
In view of
5th,
the above and on the request of learned counsel for the petitioner, for the respondent numbers 4 and 7, let this writ petition be listed again on 10th of December 2024 as a fixed item. The affidavit on behalf of the respondent numbers 4 and 5 be filed on or before 6/12/2024 by serving advance copy upon the petitioner's counsel. Yes? 6/12? You wanted 1 week, you have got.
6/12, Lordship.
Yes, 2 weeks you have got.
6/12, then it's all right, Lordship.
Yes. Yes.
Always.
All right.